The presumption of innocence is one of the golden threads that holds our justice system together. It operates as a shield between the individual and the overwhelming power of the state. The presumption of innocence forms part of the bulwark that prevents unjust and wrongful convictions. You may be familiar with a quote from English jurist William Blackstone in his seminal work, Commentaries on the Law of England. It was published in 1760, and he said, "All presumptive evidence of a felony should be cautiously admitted. For the law holds it is better that 10 guilty persons escape than one innocent suffer." He was right, because the consequences of a wrongful conviction are heartbreakingly devastating. Donald Marshall Jr., Stephen Truscott, Thomas Sofino, David Milgaard, Guy Paul Morin. These individuals were not just embarrassed, they did not just lose their jobs, their reputations were not simply tarnished, they were not denied a seat on the Supreme Court, and none of them even lost their radio show. Their lives were destroyed and their liberty was lost at the hands of the state. This is why the Universal Declaration on Human Rights holds that everyone charged with a penal offense has the right to be presumed innocent. This is why here in Canada, Section 11D of the Charter of Rights and Freedoms guarantees that any person charged with an offense has the right to be presumed innocent until proven guilty, according to law, in a fair and public hearing by an independent tribunal. But despite those lofty words, the presumption of innocence is under attack in our courts. The police and media frequently publish the names of people who are charged with a crime but who have not been yet convicted. Reverse onus bail provisions force individuals charged with offenses who are still presumed innocent to show why they should be released from jail. And the trend of a denial of bail, a reliance on minimum sentences, and abuses of prosecutorial discretion often provide a powerful inducement for innocent people to plead guilty. So it's true that we need to be vigilant against any fraying of the golden thread that runs through our criminal justice system. And even the current Liberal government, the self-proclaimed party of the Charter, is dropping the ball in this regard. Just last month, the law was passed that would force an accused in a sexual assault case, who is presumed to be innocent, to disclose evidence in their possession that shows their accuser to be a liar, disclose that evidence to the Crown and to their accuser. This is unprecedented in Canadian law and represents a true erosion of the presumption of innocence. So yes, the presumption of innocence is under attack, but the most insidious attack on the presumption of innocence in our courtrooms is not coming from Crown attorneys or from wannabe woke politicians. It's coming from those who would unreasonably see that same standard enforced in our everyday life. Insisting on the application of the presumption of innocence outside the courtroom actually diminishes it in the courtroom, where it really matters. Now that I've gotten your attention, I'm going to let you in on a little secret. The presumption of innocence is a legal construct. You see, the presumption of innocence operates in our courts to protect people charged with crimes from the overwhelming power of the state who can deprive someone of their liberty. It doesn't operate to immunize political leaders, famous entertainers, or powerful CEOs from public scrutiny. In short, the presumption of innocence is a procedural protection. To ensure court fairness, it's not a moral imperative. This is why we do not automatically convict a self-admitted murderer whose crimes are clearly captured on video. Even when guilt is plainly obvious, proper procedures must be followed and the prosecution must prove the case beyond a reasonable doubt. The presumption of innocence doesn't mean that someone is factually blameless until proven otherwise. And to insist on a strict application of the presumption of innocence, an application in everyday life, is an absurd and insidious act of complicity in the realities exposed of the Me Too movement. And watering down that presumption by using it in everyday life devalues it as a strict and exacting legal protection in our courts. Because in no other aspect of our daily lives do we employ the presumption of innocence or apply the burden of proof. The presumption of innocence, quite simply, shouldn't be used as an excuse to disregard common sense. In everyday life, if we insisted on those same in-court protections, the presumption of innocence, we would simply stop living. Every time you get in a car, there's no guarantee that you're not going to be in a car accident. There's no proof beyond a reasonable doubt that your latest investment isn't going to tank. And there's no presumption that your child's going to make it through the day unharmed. But we don't stop driving, we don't stop investing, we don't protect our kids in bubble wrap, and we don't stop living. So why is there this new and renewed insistence that we employ the presumption of innocence and proof beyond a reasonable doubt when it comes to other aspects of life, and specifically when we're looking at complaints of sexual misconduct, harassment, or boorish behavior? Patrick Brown, Brett Kavanaugh, Bill Cosby, Louis C.K., Harvey Weinstein, these are the men that an insistence on that standard would protect. And many of the same people who seem so ready to use a strict application of the presumption of innocence in day-to-day life have been remarkably silent when that protection has actually been under attack in our courtrooms. It's impossible to ignore the consequences of insisting on those strict standards, because history shows that this type of complacency in normal everyday life has led to inequity, harassment, and real harm to vulnerable members of our society. And so I know this debate exists outside the context of the Me Too movement, but of course it has to be framed by that. And so let's look at Patrick Brown as an example. There were allegations made against him, some of which were criminal, but some of which were not criminal at all. But the state wasn't trying to imprison him or deprive him of his liberty. So why should the public not be entitled to come to their own conclusions based on their own standards, whatever they may be? Why would his defenders force groupthink upon all of us? I do wonder how some of his self-styled presumption of innocence crusaders think things should have played out in that case. And this is the real problem that no one has come up with an answer for. I mean, Brown chose to step down as party leader, but should he have been encouraged to stay on? Should his caucus have been required to support him? Should the women have been compelled to a tribunal to testify about their allegations? Should the media have been forbidden to report on those allegations? And should the public have been forced to presume that he's innocent? Of course not. Any of that would have been absurd. Now let me ask you this. Would the defenders of this out-of-court presumption of innocence feel comfortable if their kid's teacher was accused by multiple students of sexual assault and that teacher kept on teaching their kids? Should a police officer alleged repeatedly to have used excessive force continue frontline policing until he was found to be guilty beyond a reasonable doubt? Of course not. If your daughter or if your sister or if your friend told you about being the victim of a sexual assault, you wouldn't expect her to meet an exacting standard of proof, and certainly you wouldn't presume the person who she said attacked her was innocent. You would believe her. And Brown's case is no different. Brown, by the way, is doing just fine. He's the mayor of Brampton. And Louis C.K. is still doing stand-up. And Brett Kavanaugh is on the United States Supreme Court the last time I checked. Remember, the presumption of innocence doesn't mean someone is forever factually blameless. I've never heard anyone say that it's better to put 10 guilty men on the Supreme Court rather than risk depriving one federal court of appeal judge of a promotion. We don't insist on the presumption of innocence or proof beyond a reasonable doubt when we're looking at other sensitive political and social issues, even when those issues could fundamentally change the fabric of our society. Now, there's room for public discussion when it comes to how we should view allegations of sexual misconduct and how we should look at allegations in general society. But we shouldn't use a legal principle designed for our courts to govern the opinions and actions of members of the public outside of court. As a practicing lawyer, I've represented people who are accused of all types of crimes, including sexual assaults. And I know that criminal allegations can destroy lives. There's no question that we need strong labor and employment protections to mitigate against consequences of unfounded allegations. And I know that false allegations happen. You can trust me, I've seen them. We need to be vigilant against any fraying of the golden thread that holds our justice system together, and there's plenty of real work to be done there. But life, politics and personal opinion have never been governed by the Marquess of Queensberry rules. And to insist on cases like Brett Kavanaugh and Patrick Brown and Harvey Weinstein, and to insist that they enjoy the presumption of innocence in every aspect of their life does real harm both inside and outside the courtroom. And at the end of the day, that's why insisting on the presumption of innocence and proof beyond a reasonable doubt outside of the courtroom actually leads to and doesn't protect from injustice. Thank you.
Before I begin my formal remarks, I think it's important for you to know that there is a history to this debate between Mr. Spratt and myself. You see, Mr. Spratt and I agree on almost everything. We're vocal members of the defense bar, zealous defenders of the rights of the accused, and harsh critics of the overreach of state power. As a result, I have never been on the receiving end of his ire, until now. You may have noticed today that I'm walking with a cane. The reason is that last weekend, in a fit of anger that I dared to oppose him on such a fundamental question, Mr. Spratt threw a bowling ball at me, puncturing my left lung and causing me to have to go to the hospital for emergency surgery. Given his position that the presumption of innocence need not apply outside of a criminal courtroom, I was rather hoping that Mr. Spratt would spend his 10 minutes that were allotted to him defending his inconceivably violent actions against me. After all, this debate is not a criminal proceeding. If the presumption of innocence doesn't apply in this circumstance, then the presumption of guilt does. And you, my friend, are a violent, impulsive agent of the patriarchy until you prove otherwise. In fact, Mr. Spratt should lose this debate, not on its merits, but simply because I have made an accusation against him. But that's not a big deal, right? I mean, it's not his liberty at stake. He may just lose this platform. He may ultimately lose his livelihood, perhaps his wife, the respect of his peers, the love of his children, and any dream for a happy and prosperous future that he's worked so hard to build for himself. But that's an acceptable sacrifice to make at the altar of #WeBelieveSurvivors. Don't get me wrong. There is a time and place to believe someone who reveals something as devastating to you as a sexual assault. If my sister came up to me and told me that she had been sexually assaulted, I would believe her and support her with all my love and my resources. But in my mind, that is a different exercise than shifting our entire public orientation to presume that a person accused of sexual assault bears the burden of proof to answer that allegation outside a criminal courtroom. We, in Western democratic societies, have tried for hundreds of years to come up with organizing principles, ways of structuring public lives that balance justice and fairness, and that promote freedom and autonomy. One of the principles that emerged from the Dark Ages, where suspicion, conjecture, and rumor controlled people's lives, was the enlightened position that an accusation is not proof of guilt. In the criminal justice context, it is the legal principle that one is considered innocent until proven guilty. It is traditionally expressed through the Latin maxim, "Ai incumbit probatione qui decit, non qui negat," meaning the burden of proof is on the one who declares, not on the one who denies. This is not just a legal principle, it is a way of knowing the truth. It is an epistemological orientation. Without the presumption of innocence, the accusation is proof in and of itself, and it is the condemnation. We are lucky that the reasoning behind the presumption of innocence infiltrates our public consciousness and manifests itself outside of the criminal justice system. It is present in the civil justice system as well, While the standard of proof may be different, balance of probabilities being 50% plus 1, the burden is still on the claimant to make that 50% plus 1. It is in our workplace regimes, it is in our dealings with members of the profession and our professional associations, and in allegations of doping at the Olympics. Imagine a society where children grew up knowing that all they had to do to win an Olympic medal was to accuse their competition of cheating. There would be no incentive for truthfulness because there would be no threshold for proof. There would be no incentive for people to excel because they could tank their opposition with a mere allegation. And it would rest on the other person to spend their resources and time to prove their innocence. That is why the presumption of innocence is not just important in the criminal context, it is also important outside in our daily dealings with each other. Even if we are to believe that no false allegations exist today, eliminating the presumption of innocence from our epistemological framework such that to know a fact requires no proof from the person who posits the fact, there will be false allegations. We can count on it because there are no barriers to entry. It would be utter chaos, utter social paralysis. This would create a society that would be the exact opposite of the justice, fairness, freedom, and autonomy that we so deeply value. This is why the presumption of innocence is not just an important principle in the criminal justice system. It is a fundamental principle of our democracy. The presumption of innocence is a tool that allows us to suspend judgment about a claim until we get proof from the claimant. That is what it is. It helps us make better and fairer decisions. And it's crazy that this tool should be available only in the criminal justice system, when so many people today are actually foregoing the criminal justice system altogether and meting out their own version of #justice that impacts the lives of so many individuals. Thank you.
Michael, your rebuttal.
I'm innocent. And of course I am. Because I wasn't in Toronto when Annamaria suffered her injury. I've never touched a bowling ball. You could look at my past acts and see that I've never been violent in my life. What Annamaria offers is a false dichotomy. Either there's a presumption of guilt or there's a presumption of innocence. And of course, everyone in this room is smart enough to see through false dichotomies because we're not left with an either-or choice. Members of the public can make their own decisions. I have the right to answer Annamaria's bizarre claim. I have the right of free speech to respond. I can resort to libel or slander laws. There are other remedies, and to say that one starts from either a presumption of guilt or a presumption of innocence devalues the good common sense of all of you. And of course, that comes with a cost, and we've seen what that cost is. We've seen that a strict adherence to a presumption of innocence hasn't disadvantaged people like me. It's disadvantaged people who are vulnerable. It's disadvantaged women, minorities, and people who are not like me at all. Now, I think that we have to be careful of false premises. Because without a presumption of innocence, an accusation doesn't equal proof, as has been suggested. Without a presumption of innocence, an accusation is an accusation, and people can come to their own conclusions. Because there are always burdens imposed on individuals who make claims. That's why we may believe our neighbor when they make an allegation of sexual assault. But we may not believe our neighbor if they make an allegation of sexual assault perpetrated from an alien, from a different world, because we have good common sense. We don't need to resort to in-court procedural protections, because burdens are imposed in courts, in tribunals, and all talk about the presumption of innocence focuses on those places, both in the Universal Declaration of Human Rights, in the Canadian Charter of Rights and Freedoms, and by a judge who I probably don't often agree with, Justice Rehnquist, in the Supreme Court in the United States. But never has it been said anywhere that these presumptions should exist in daily life. And there's a good reason for that. As I said in my opening remarks, when we insist on the strict court protections and those presumptions in everyday life, it devalues those protections in court where they really matter. When we tell jurors that they have to be sure beyond a reasonable doubt, we don't want them thinking about the presumptions that they brought to bear in their everyday life for situations that pale in comparison. It's a bit of a straw man argument to say no presumption of innocence means chaos because we don't need proof. Suspending one's judgment until there's proof can lead to dangerous and damaging results. And so you may think of it as an act of balancing, or you may think of it as common sense. And the reason why you should be hesitant to accept proof beyond a reasonable doubt in your everyday life is because nowhere in this debate, not in the Patrick Brown case, not in the Brett Kavanaugh case, in no case has anyone suggested an alternative. What's to happen? What standard? Is it proof beyond a reasonable doubt? And if we don't engage proof beyond a reasonable doubt, that other golden thread in the criminal justice system, the presumption of innocence is sort of meaningless. Because if you can displace the presumption of innocence with something less than proof beyond a reasonable doubt, it's a pretty hollow right. And actually in the Islamic constitution, Iran has a presumption of innocence in their constitution, but that doesn't give me great confidence in their justice system because it doesn't go hand in hand with the other golden threads that we have. And the fact that no one's been able to suggest a better system, a system that wouldn't compel people to come forward, that wouldn't compel silence, that wouldn't compel groupthink, that wouldn't compel people to disregard their good common sense, or wouldn't compel people to throw away the presumption of innocence with some other lesser standard of proof, goes to show that the presumption of innocence, those words are legal words. And in everyday context, they lose their meaning and can be devalued if insisted upon. Thank you.
Annamaria?
I think that Mr. Spratt also sets up a straw man argument in that he is attempting to transport the presumption of innocence in its strictest sense outside of the criminal justice system. I think the presumption of innocence is a useful tool, as I've mentioned, in order to understand how to make sense of allegations. Allegations also exist outside of the criminal context. It is a tool that is helpful in determining a way to structure our society and our relations with one another in a way that makes sense, and that is that the claimant bears the proof of the claim that they are making, not the opposite. The opposite, as I mentioned, would be preposterous. Now, the items or the elements that Mr. Spratt listed as being incompatible with the presumption of innocence in the strictest sense, such as protections that people might need if we are not to suspend our judgment, if they are facing, for example, a teacher who continues to teach at a school, if they're facing allegations of multiple sexual assault against children, or if there's sexual allegations in the workplace. Those kinds of risks are also taken care of, are also addressed in the system that applies the presumption of innocence in the strictest sense. In the criminal justice system, we have a bail system that balances the risk to society with the presumption of innocence of the accused. There's a balancing act that goes on, and it is not the presumption of innocence that rules everything, even in the criminal justice context. So a person who is accused of sexually assaulting someone may face a bail condition that prohibits them from contacting that person. And therefore, these concerns that we have that might arise if we impose the presumption of innocence, they don't even arise in the criminal justice context to begin with, where the presumption of innocence is applied in the strictest sense. And the statement Mr. Spratt has made on a number of occasions is that insisting on the presumption of innocence outside the criminal justice system devalues its importance within the criminal justice system. I have not seen any evidence cited by him that that is the case. How does it do that? Saying it over and over again doesn't make it true. We haven't seen that that is the case. In fact, what we've seen is the opposite. The insistence and the continued reminder by our media that our criminal justice system functions with a presumption of innocence has led to the hashtag justice vigilantism that we've seen online with individuals going after others by creating hashtags and attempting to met out a kind of justice on the basis of the fact that they resent the presumption of innocence in the criminal justice system. They see it as a failure. So I think that there's a lot that we can learn from the criminal justice system's presumption of innocence, but I think it doesn't need to be the strictest articulation of the principle of the presumption of innocence. We can water it down, we can learn from it, but there's certainly a place for it. It is a tool that we as a society can use in order to make better decisions about how we regulate each other. It is unfair to say that it has absolutely no place outside of the criminal justice system, because robbing people of that very important instrument that we use to reason through complex problems can really do no good. Thank you.
Okay, so I have a question for Michael and a question for Annamaria. First question is for Michael. You mentioned in your opening comments, well, if a teacher was accused of misconduct or a cop, you wouldn't want those people to still be circulating throughout society. And of course, that is the instinctual response. But isn't part of the bargain of living in a liberal democracy that we have to overcome those sort of vigilante instincts? And yes, you know, if a judge is determined that this individual who's been accused of a crime is not an imminent violent threat, yes, they do get to circulate throughout society, and we have to deal with it, even if it makes us a bit uncomfortable, because the alternative, that they be shuttered into their house and shamed, is clearly not acceptable to our liberal norms.
Yeah, I mean, all too often right now, that's exactly what happens. People who are accused of crimes and who are before courts where they do have these important protections, including charter rights, are shuttered into their house and are prohibited from doing certain activities. But that, of course, isn't the case that we're talking about. We're talking about cases that are one step removed from the justice system and from those sort of controls and legal norms. We're talking about cases that don't make it to the criminal justice system where there wouldn't be those presumptions. And I don't think that there's anything necessarily wrong or inconsistent with individuals like myself who believe in these important protections also being very concerned about having them transported outside of the courtroom. Now, what this does mean is that we need to have a very real and honest conversation about what that looks like in society. One of the things that I see a lot in my day-to-day practice are people who are accused of crimes and who lose their jobs automatically, who get put on leave without pay while they're presumed innocent. And that's something that we need to work on, but we don't need to import these concepts like the presumption of innocence into everyday society, because we get left with these sort of absurd results. What we do need to do And what I hope that proponents of sort of this way of thinking that we need these stronger protections can look at is legislative action to make sure that there's those improper employment standards and occupational health and safety and union protections that some of the most privileged professions like police officers have when they face these allegations. And with some of those protections, perhaps legislatively, it allows everyone to take a breath and to deal with these sort of very important questions in a more deliberative way.
Isn't that on some level an application of the presumption of innocence outside of a criminal courtroom?
I mean, of course it is, and I'm not arguing that you are prohibited from presuming someone is innocent. I'm arguing precisely the opposite. You should be free to make that call yourself based on whatever standard you want. The problem is when you start using terms like presumption of innocence, when you start doing what Annamaria is suggesting, using the watered-down version in society, the last thing I want a jury to do when they're deciding whether a client of mine should have his liberty taken away by the state potentially for the rest of his life is to be thinking about a watered-down version of a presumption of innocence.
I'm going to ask Annamaria a question, then we're going to go to audience Q&A. So if you want to start lining up behind the mic, if you have questions for either of the debaters. Annamaria, you spoke about stigma that can spread rapidly in the digital age and increased just virality of reputational harm. Do you think that the criminal justice system should implement a mechanism for recognizing those types of harms, perhaps at the sentencing stage or at any other stage of the formal criminal procedures?
It already does. So the harm experienced by an accused that they experience that is sort of the tangential harms or any kind of outside harms that they experience as a result of, I think they're called collateral harms. So any kind of collateral harms that a person experiences as a result of their charges is considered on sentencing. So a person can, and I've been in on high-profile cases where we have filed screenshots of letters received to newspapers from individuals who basically wanted our client drawn and quartered, and the kind of vitriol that was put to not only sent to him, but also his family. So there already is a mechanism whereby courts can, and increasingly so now after the Souter decision from the Supreme Court of Canada, that courts can take into consideration the collateral consequences, broadly the collateral consequences defined not only as the consequences of the conviction, but also the consequences of the offense itself. That's kind of a brutal case. It's a man was, I'm going to tell the story because it's you got to hear it. So a guy was accused, was driving, he had a momentary lapse of attention and drove his car into a restaurant, killing a 2-year-old child. He was immediately dragged out of the car and beat up by individuals in the restaurant. Beaten up. Right, but then subsequent to that, there was also an aspect of him receiving bad legal advice about a breathalyzer test, but I'll put that aside. But subsequent to that, he was kidnapped, as was his wife, by vigilantes, and he had his thumb severed. And the discussion in the case was whether the thumb severing as a collateral consequence could be considered as a collateral consequence, because it wasn't collateral to the offense, really, or to the conviction. It was kind of a vigilante violence, whether that can be taken into consideration. And the court said that it could, and sort of expanded what is the collateral consequence that can be taken into consideration. So I would say that yes, social justice vitriol, particularly the kind that forces people off of social justice platforms, can be filed as evidence, as evidence of collateral impact.
Hi, first of all, thank you so much. That was really interesting. I have a question that has 2 parts. So about this, it's for Michael Spratt. So about this division between everyday life and and what we do in courts, I'm not sure that I follow, because according to what I understood, what courts do is actually deal with what happens in everyday life. So my question is, like, the European Court of Human Rights has held that the presumption of innocence is also a personality right. And so, like, in the French Civil Code, there's an article that says that a person can file a suit for defamation if they've been accused by someone, and that the defense of truth doesn't hold until that person has been convicted. So that would be like my first question. The second one is, if we separate factual and legal guilt, don't you think that a jury would be biased by what they've read in the newspapers, and so that factually they may convict someone based on what they believe? And I would refer you to something you said, which is, I think that we have to be careful of false premises. Thank you.
Well, I'll start with your question about the European Union and say that one of the first things I learned as a lawyer is to never offer any advice or opinions where I'm not an expert on the area and aren't insured to do so. I know nothing about defamation law in the context of the European Union courts, but I can address your question about courts and juries and, you know, courts using, as I think you suggested, sort of everyday logic in courts. And it's true that we tell members of juries to use their everyday common sense. But everyday logic actually doesn't have much place in our courts. There's lots of exclusionary rules and evidentiary rules that operate precisely the opposite. If you look, for example, at someone's prior history, quite often in court, and looking at, say, a bank robbery case, if an accused is on trial for a bank robbery case and the Crown wants to introduce their criminal record, quite often there are limits about what can be on their record. And sometimes the record is actually sanitized to remove, for example, other bank robberies, because the court doesn't want necessarily the jury to use their everyday logic. Twice a bank robber, probably he robbed this bank too. But that is something that we do use in everyday life. You know, if someone has committed a fraud on you twice, you know, you paid the money to shovel your driveway, and twice they haven't followed through on that, and they come to your door the third time offering you the same service, you're probably going to say no and judge them based on their past acts. But quite often in courts, we actually see great pains taken not to engage in that type of reasoning. And sort of that links into your question about jury bias. There's very robust systems in place, and there's procedures in place to make sure that juries aren't biased, specifically by excluding some of this everyday thinking that we do in public.
Hello, Mr. Spratt. You've done a remarkable job of defending what I think is a difficult position in front of this crowd. But have you not conflated a burden of proof with a standard of proof? Because you've mentioned beyond a reasonable doubt, and the presumption of innocence has absolutely nothing to do with beyond a reasonable doubt. They're separate concepts. One is a standard, one is the burden of proof. And I think presumption of innocence is summed up by the Latin dictum that Ms. Enenajor used. And it is about purely a burden of proof. And so I don't quite understand your concern about juries misunderstanding the rules they're bound by a watered down concept of presumption of innocence, when in and of itself it is a very simple, neat concept. It is not, again, anything but a burden of proof. Thanks.
Yeah, I thought initially when I agreed to come speak here that this might be a tough position to defend in front of this crowd, but then I realized that all you guys are into freedom and personal choice and not having people not tell you how to think. So I actually don't think it's a very hard position to defend. Now, I didn't understand Annamaria when she used the Latin quote. I have vowed never to speak Latin as a lawyer because I think it's a bit overdone. And quite frankly, the last guy in court who spoke Latin didn't know what he was saying and used one Latin term to define another Latin term, and it devolved into a mess. So
I provided the English translation right after.
I know, I Google Translate going, I trust you. But I disagree with your premise that the presumption of innocence and the standard of proof beyond a reasonable doubt have nothing to do with each other. These are both golden threads that are intertwined with one another through our criminal justice system, and one is never talked without the other. Because if the presumption of innocence can be displaced on any evidence or scant evidence or evidence that is lacking the rigor that we count on when we talk about proof beyond a reasonable doubt, it is a rather meaningless right. So I think they are intertwined, and I would suggest otherwise, and so I think that might be the difference that you and I have in evaluating that.
In Hammurabi's code and other legal systems, the false accuser could be subject to the same offense as their accusing. Do you think the way things we have set up now strikes a symmetry there, or do you think something needs to be changed? Like, because we have defamation and things like that, but...
No, not at all. I mean, when you accuse somebody, the impact to that person is almost immediate. In order to get recourse for a false accusation, first of all, it's really hard to get any kind of media to publish updates or retractions of newsworthy events. We've tried to do so in some of my cases, and they're just not interested. And second, in order to get any kind of compensation for a false accusation, you have to shell out a whole lot of financial capital in order to do so, in order to get anywhere. And defamation suits are not easy, they're not cheap, they take a long time, and are oftentimes not even worth it. So there's a quick way of making an accusation and not a quick way of vindicating yourself against the accuser. So
I'd like to start out by saying Michael turned me into a newt, but I got better. So that's Monty Python. My question for Michael is, when we're discussing the Kavanaugh case and comparing it with something like Bill Cosby, the Cosby case, appealing to the reason and reason faculties of this room is one thing, but I think a lot of us here are in attendance because we see the breakdown of reason, certainly in public judgment, and certainly online in the Twitter and what have you. So I think there's a difference between you seeing the number of accusers in the Bill Cosby case and the number of accusers and the veracity of the testimony in the Kavanaugh case. And I'm curious to know if you would believe, or what your view was on the Kavanaugh sort of process. And if I could, to Annamaria, if it is true that in, let's say, sexual assault cases, because a lot of times it's levied that it's very hard to convict in sexual assault cases. So if we grant the assumption, if it is true that it is much harder to prove beyond a reasonable doubt in those cases, as a society that values justice, do we merely accept that in those cases that we just have to let more guilty people go in that sense? Or is there something more that can be done?
Well, I think any discussion of the Brett Kavanaugh confirmation process might take us down a rabbit hole that will take up the rest of time. I mean, I think it's fair to say speaking personally, at the end of that confirmation hearing, I might have been left with a doubt about what happened. But that doesn't mean that the presumption of innocence applies and Mr. Kavanaugh should have got his appointment. I mean, quite frankly, his comportment at the hearing, regardless of the allegations, I think disqualifies him from any seat on a judicial body. And certainly the Federalist Society down south, I think, has no lack of other judges to draw from to fill that appointment. But I think that it sort of illustrates what the problem can be. Because is that Brett Kavanaugh process what we're going to engage in in society when there isn't criminal allegations? Are we going to drag people before tribunals to have them publicly examined? Because that's what the presumption of innocence and a strict application of it would suggest. I think that part of the problem is when we look at sort of the viral harms, as it's been called, about accusations, I think there's a problem with respect to thinking that you might be the victim of a viral harm, of a false allegation. And that is something that I think we need to move away from, because no one is leaving this room today thinking, holy crow, I could be falsely arrested by the police outside. I don't think anyone is going to think that, and nor should anyone in this room think, I could be next. The next false allegation should be against me. That sort of thinking, I think, embeds this status quo, and it doesn't lead to the sort of balance that Annamaria talked about. There is a balance here, and it's impossible to look at what an insistence on a strict standard of proof or presumption of innocence would mean in everyday society when you look at that balance. Because there may be false allegations made. Those are probably going to be pretty rare. But you have to look at, I think, the balance of what happens if you insist on those strict applications. And the balance is real and measurable harms to individuals. So that's all I'll say on that. And I forget what the question was, Maria.
Oh, it was about the premise was that sexual assault cases, it's hard to convict in sexual assault cases. I don't know where that rumor comes from. I haven't seen any empirical evidence to support it. Certainly in my practice and in the practice of defense counsel that I practice with and associate with, people are regularly convicted of sexual assault. I think that there is a statistic that was floating around the time of the Ghomeshi trial that only 1% of sexual assaults had some kind of consequence in the criminal justice system. So that is, there was a number of sexual assaults, then they weren't reported, and even if they were reported, they weren't believed, and the ones that were believed weren't prosecuted, and the ones that were prosecuted didn't result in an acquittal. So I would accept that, and Robin Doolittle did an extremely important empirical analysis of reporting of sexual assault allegations and how they're dealt with by the police, and how many of them are deemed to be unfounded and therefore no charges are laid. So you lose allegations at that stage. You also lose a lot of allegations at the stage of people opting out of reporting sexual assault to the police for various reasons. Also because the degree of sexual assault may vary, and like I was on the subway 3 months ago and a guy touched my bum. I'm not going to go to the police, and that's a sexual assault, definitely a sexual assault. I turned around and I told him what I thought, but I'm not going to go to the police. It's just things like that happen. So they're people who opt out of the criminal justice system. Then there are people who are sincerely suspicious of and fearful of the criminal justice system, who have legitimate, very serious sexual assault events happen to them and choose to opt out. So you lose a bunch of people there. So in terms of the actual amount of sexual assaults committed in society, and then the ones that are taken to trial, I can see us losing a bunch to that stage. But once you get to trial, I would be very surprised if the sexual assault acquittal conviction rate is extraordinarily different than other assaults. I don't know. I haven't seen any information about that. And the only statistics that I've seen are the ones that cite reporting of sexual assaults versus convictions. So they're huge, like occurrences versus convictions, huge disparity. But I would say the same disparity exists with simple assaults.
Yeah, I'll just add, I think Annamaria is right on that. When you look at, once you get charges into court, there isn't a disparity between convictions and acquittals in sexual assault as compared to other cases. And that's in spite of the fact that there are policies that Crown attorneys have that preclude them in a number of cases from diverting or pleading down or withdrawing those cases. So as compared to other cases, you're more likely to have a weak sexual assault case where there's reliability or credibility problems actually make it to trial. And despite the fact that more of those weak cases might actually make it to the courtroom floor, I don't think that there's necessarily less convictions as compared to other offenses.
Well, thank you both. I think both the presumption of innocence and free speech is very important principles in our society, and both are very important. I have a question for Annamaria. You mentioned about presumption of innocence outside of the courtroom. How would you be able to enforce that? Are you suggesting, for example, a media ban, or that the police are not supposed to publish people's names, or people are not allowed to, potential victims aren't supposed to talk about it, in the public? Where does the limit lie, and how would free speech be impacted if that is the case? I do realize that without the presumption of innocence, that people's lives can be impacted greatly. For example, the people you mentioned. But what do you think about the defamation laws? Do you think that suffices? Does it solve the problem? For example, if in the Patrick Brown case, if he can prove that the allegations are false, then he could simply go to court and file a defamation claim on his accusers and claim damages in the court. Would that suffice for you? What would be your proposed solution to enforce the presumption of innocence outside of criminal matters? Thank you.
Okay, so the first question is about the enforcement of presumption of innocence. I don't purport to enforce the presumption. I'm not enforcing anything. I don't want to enforce anything. I want to make it available as a principle that people can draw on in order to make better decisions about the allegations that are floating around in our society. But just to follow up on that, there are jurisdictions where the presumption of innocence is taken more seriously, or the impact that an accusation has on an accused are taken more seriously. And to that I would direct you to the way that criminal justice is designed, or the way that laws around this area are designed in Germany. So in Germany, it is illegal for the police to publish the name of an accused in a criminal investigation, and to publish details about the accused in a criminal investigation. And this is to protect the accused on the chance that the criminal investigation falls apart, because many of them do. 50% of cases that are brought into court end up being withdrawn. We don't have a perfect criminal justice system, and people's lives continue to be destroyed by mere allegations. So jurisdictions like Germany, where they have a more robust concept of personality rights in the civilian tradition, they've recognized the importance. They also have the right to be forgotten. There was that important case out of the European Human Rights Court about the right to be forgotten, whether you can sort of de-Google yourself. There's a very robust understanding of privacy and a deep respect for privacy that I think we're going to see our Western society start to draw from as we enter into an era where we are essentially obliterating our privacy rights every day. So, and then there was a second point to your question.
Defamation laws.
Oh, defamation laws. Right. So, I mean, ideally, you want defamation laws to not have to have recourse to defamation laws, but for the damages in defamation cases to be so great that they would deter people from making false accusations. And we don't have those kinds of recoveries in Canada. The amounts for defamations are not so extraordinary that it would deter an individual from making a false allegation or think twice about making a false allegation. So the amount of damages that can be recovered is something that in all of our civil cases, like you get $5,000 for losing your thumb to a police officer or something like that. Like our recoveries are very, very low in Canada for all civil cases, but defamation certainly as well.
Yeah, it's generally not worth it to let a police officer take your thumb for only $5,000. But I will add, when we're talking about rights, they're pretty hollow without a remedy. So until you can suggest what the remedy should be, what the recourse is, it's sort of hard to suggest that there's these hard and fast rules and rights that people have in general society. And I think Annamaria and I violently agree on a lot of things, especially when it comes to the state. And I think that that's the point that I would like to leave you with. There's a difference between the state trying to do something, the police publishing your name or prosecutors trying to take your liberty, and another member of the public making comments, using their rights to free speech, and you as a member of the public then using your intelligence and your common sense to react to whatever that person said.
Yeah. Oh, just as a final note, I just want to clarify that Michael Spratt had nothing to do with my collapsed lung.
Finally vindicated.
I wanted to thank both of you for this panel. I think it's absolutely critical, the whole issue of the presumption of innocence, simply because most of the world still does not have it. So we must protect it with, really at all costs. It's preserved under both Section 7 and 11D, and a common thread runs through those. I wanted to make one comment about Annamaria's Latin pronunciation. It's beautiful, almost second to the Pope. With respect to what I wanted to say, first of all, just a quick recommendation. Everyone in this room should see it, required viewing in my opinion. It's simply, look it up on YouTube. It's called The Trial of Gian Ghomeshi. Even if you're the most fervent of CBC haters, it must be seen, if just to see how defense counsel should act during cross-examination, but also to see how that entirely went, because most people are not aware or forgot about it already. Pay particular attention to the 24-minute mark. The second thing is something that has not been mentioned today at all, and I'm sure next year will be devoted to at least one or two panels, is Bill C-46, the amendment of the criminal code for drug and alcohol-impaired driving. Under that, the police have the right to take your blood, any one of our any one of us at the roadside, without probable cause, without a warrant. And that is, of course, you're not presumed innocent in doing that, and you're not allowed to reject it. And someone whose heart is racing, whose blood pressure is sky high, whose pupils are dilated, they could be on cocaine, they could be on methamphetamines, they could be chronic anxiety-ridden people, or they could just be deathly afraid of the police. Yet, Supreme Court ruling in 2017, R.V. Bingley, basically emboldened the current government to pass that law. Your input, again, I thank you very much for your panel.
There's definitely problems with respect to Bill C-46 or the new impaired driving rules, especially when it comes to the presumption of innocence, because there's actually de facto reverse onus provisions in those where an individual who's not driving is going to have to prove their innocence. And Annamaria was really outspoken on the companion bill, Bill C-45.
And Michael and I presented on both bills on behalf of the Criminal Lawyers Association before the Senate committee.
So there are definitely things to be talked about there, and I mean, just today, the National Post in their op-ed said I was right. So the National Post called me right, but I will leave you with this on C-46. The irony, and there are huge discriminatory problems and systemic racist issues in that bill with how it's going to impact minority groups. The irony isn't lost on me that it took a 70-year-old white man being pulled over by the police for the media and some of these editorial pages to start commenting on that. So I think that it's good that we're looking at these issues.
Yeah, yeah, the bill is incredibly problematic. We're going to see a lot of charter challenge around it, and it's disappointing coming from this government. But.
Last question, Andy.
Thank you. There is a thing, that Twitter thing. It's hashtag thank Joanna for a great conference.
It's not over yet.
So, did I say that right? Hashtag, anyway. So I got 3 criminal lawyers. I rarely interface or interact or deal with criminal lawyers. This is really...
Probably a good thing.
Yeah, I'm really excited. I would like to ask the 3 of you, all, including Joanna, because you used to do this. Is there a threat of outside publicity tainting the judicial process? I mean, is that a reality that you worry about, that lots of news affecting a jury? You talked about the robust stuff. Never having dealt in your forums, I don't believe that. I don't believe that judges don't read newspapers and carry something in. I don't believe juries do. I just wondered, from your perspective, what do you think?
I think that there is a risk of juries being influenced by things that they hear in the media. And I mean, this is perhaps another problem that we have in some legislation. In Canada, we don't have very good tools to try to determine whether that's the case or not with any specific jury. Now, I'm going to push back a little bit on judges being influenced by what they read, because I'm sure judges are human, and to some extent or the other, judges can be influenced. But every judge that I've appeared in front of, every judge who I know personally, takes great pains to avoid that. And that is part of the training and education. And indeed, I have got lots of acquittals for clients who the judge knows has a long criminal record for similar behavior. And they know a lot of prejudicial information one way or the other, just on, I know because of how they're looking at me, and they still acquit. So I think judges are very well equipped to deal with that, but I do think that we need to be concerned when we're having lay juries who don't really have to say why they came to the conclusion they came to.
Yeah, I would agree. The only thing I would add is that with respect to juries, we have, you can change the forum, you can apply to have the forum moved to try to go to a jury pool that's less prejudicial, that may be less prejudicial, but in an era where everybody has access to online media, it's difficult to move your jury to any place where there wouldn't be somebody who would know something about the case if it's a notorious case. But I think one of the things that we do need to develop in Canada is more robust ways of vetting juries. The recent bill that's before, I don't know what stage it is at now, Bill 75, before the Senate, is before the Senate. It's proposing to remove peremptory challenges for jurors and not replace it with any kind of Batson-style jury inquiries, but that's another topic altogether. But it's just to say that we don't have enough equipment to be able, we're not well equipped in our legislation to be able to ask juries the kinds of questions that we would want to know about whether or not they have whether they have existing biases or whether they have existing knowledge about the case and how that would impact their decision-making process. So that's something we have to work on.
I agree with what both of you said. I'm slightly a little less optimistic than Michael. We maybe have just had a few bad experiences where I'm less optimistic about judges always being so pristine and impartial. And yeah, I think juries are a huge problem. Did you guys hear there was a story about a juror who fell in love with the prosecutor and started sending amorous emails to the prosecutor and said that she would convict on the basis of her love for the prosecutor. So at least there was some type of digital record for it.
The Court of Appeal didn't seem to have a problem with that. And I haven't got any love letters from juries, so I'm doing something wrong.
Well, thank you very much. This was an excellent conversation.